The case that I'm presenting is Wulf versus Bravo Brio Restaurant Group 2019. This is a civil appeal from the Butler County Court of Common Pleas to the 12th Appellate District Court of Appeals in Butler County. William Wulf, the executor of the estate of Roland Wulf, is appealing a trial court summary judgment in favor of the defendant, Bravo Brio Restaurant Group Incorporated. The original trial court case was a suit for damages as a result of the negligent behavior of a Bravo Brio employee. The plaintiff, Roland Wulf, suffered an injury while dining at a restaurant owned by the defendant, Bravo Brio Restaurant Group. At some point during dinner at Bravo Cucina Italiana in Westchester, Ohio, Roland Wulf went to the restroom and someone bumped into him on the way there. He fell to the floor, resulting in a fractured hip. Roland Wulf did not say who bumped into him, but he asserted that a slender woman in her 20s with brown hair and wearing a Bravo uniform apologized for the incident and acknowledged that she worked for Bravo Brio. No one in Roland Wulf's party witnessed the incident, and Roland Wulf was unable to specifically identify the woman. Roland Wulf would be deceased before the conclusion of the trial court case, and the estate of Roland Wulf resumes as plaintiff for the remainder of the trial court case and as the appellant in the appeals case. The three issues in the Wulf versus Bravo Brio 2019 case are: one is specific identification of a subordinate required to establish negligent liability under the doctrine of respondeat superior. Two, what types of hazards does the open and obvious doctrine apply to? Three, was it appropriate for the trial court to grant a summary judgment in favor of Bravo Brio? And the way the court ruled in this case are: one, a plaintiff is not required to specifically name and identify an employee to establish employer liability under the doctrine of respondeat superior. Two, the open and obvious doctrine only applies to static hazards. And three, it was not appropriate for the trial court to grant a summary judgment in favor of Bravo Brio. The way the appeals court applied the law in this case is that the appeals court determined that a negligent individual needs only to be identified as an employee, and that the employee needs to be determined that the employee was negligent while acting within the scope of employment. But the employee doesn't need to be specifically named as a plaintiff or specifically identified in order for respondeat superior to apply. The appellate court noted that Bravo Brio cited a number of cases regarding respondeat superior where the negligent individuals happened to be identified, the negligent employees, but they cited cases where the specific individual wasn't named or like specifically identified other than as, generically as custodians. And in this case, the appellate court decided that it wasn't necessary for them to establish such a requirement in this particular case. Regarding the open and obvious doctrine, the appeals court applied it as they pointed out that the open and obvious doctrine only applies to static hazards such as the building premises, the building, the fixtures, and they go over the definition of what open and obvious is and how the premises owners does not have a requirement to protect their business invitees from hazards that are self-evident, meaning like if you could see that there's a problem there, it should be obvious that you should avoid it. And, there's no reason for a business owner to, protect an invitee from things that are obvious. And in this case, the Bravo Brio asserted that the open work area where the waitresses and all the wait staff worked was an open and obvious hazard, but the appeals court made a distinction between like a static hazard and a dynamic hazard. In this case, the open work area was considered a dynamic hazard because it's something that changes, and it's more dependent on how people are behaving while they're working in that area rather than the work area itself as being necessarily dangerous. In the original trial court case, Bravo Brio asserted that Roland Wulf made an assumption of risk as far as walking too close to the waitresses in the in the working area. But in the appeals case, the appeals court determined that it's important that the premises owner, they have a separate duty from open and obvious, and it's just not to conduct negligent activities. Most of this case actually spent most of the time, most of the writing in this case was related to whether or not the summary judgment was appropriate. And in this case, the appeals court went item by item as far as like what they considered uh, evidence, appropriate evidence to introduce into the trial case. The main thing is that in order for summary judgment to be appropriate, there must be no issues of material fact. And so in this case, in the appeals case, Roland Wolf's party, um, they would go like piece of evidence by piece of evidence and say, there is an issue of material fact because this was omitted in the trial court case, but this is actually something that we're disputing here. And then in other cases, pieces of evidence for summary judgment to be appropriate, it needs to be construed in favor of the non-moving party. In other words, Bravo Brio was the one making the motion for summary judgment, so it would be Roland Wolf, the non-moving party, who the evidence has to be construed in favor of. And this is another point where they would go piece of evidence by piece of evidence and say, this was actually not construed in my favor. And so this has to be, this is a mistake that the trial court made. And so the appeals court would go piece of evidence by that Roland Wolf went over and determined, yeah, there's a difference here of material fact. And then, yeah, this was also construed in a way that wasn't favorable to Roland Wolf. And there was like one piece of it, like for example, there was one piece of evidence where like the waitress's statement, that's a piece of evidence, right? And she acknowledged that she bumped into Wolf, and Bravo Brio asserted that this is not admissible as a piece of evidence. Like the waitress admitting that or the waitress's apology to Roland Wolf was not admissible as evidence because Bravo Brio said it's out of the scope of employment to admit responsibility for the accident or to admit liability. But the way the appeals court looked at it, they said she's not assuming liability. She's actually just stating a fact that she bumped into him. And that's totally within the scope of employment, like asserting that she's not asserting liability by saying, sorry for bumping into you. She's just stating a fact. I bumped into you. I'm sorry for that. And so like that's how the summary judgment issue went. Like they would go look at all the evidence and then decide whether or not it was originally admissible or whether it should have been omitted. And so at the end of this case, the trial court's judgment was reversed and remanded, and in that case, the case is sent back to the trial court the trial court, and they have to do it all over. But since there's no subsequent case history, I asked Donald Jones about that, and he was explaining it. It's probable that they either decided not to pursue any further, or Roland Wolf decided not to pursue, or the estate of Roland Wolf decided not to pursue any additional actions, or they probably just settled, and that was basically the end of that. So that's the whole case, and that's Wolf versus Bravo Brio 2019, the appeals case.